Assalamualaikum and good day. Today I will be presenting an industrial court case titled Muhammad Fauzi bin Muhammad Sharif versus Bank Islam Malaysia Berhad, reported in the Industrial Law Journal Unreported 2025. This case examines the question of whether the dismissal of a senior employee was carried out with just cause or excuse, which is the core legal test under Section 20 of the Industrial Relations Act 1967. So, for the introduction, to begin, this case involved the claimant Muhammad Fauzi, who worked with Bank Islam for more than 11 years. He held a senior position as the branch manager of the Alostar branch. On 17 January 2022, he was dismissed from employment after the bank alleged that he had been sleeping in his office during working hours on 11 different occasions. The claimant disputed this dismissal and filed a representation under Section 20, claiming he was terminately unfairly and without just cause. The court that had to determine whether the bank's action was justified and whether the punishment of dismissal matched the seriousness of the misconduct. Okay, on this slide, which is facts of the case, now let's look more closely at the facts. Fauzi had joined the bank in 2010 and eventually became a branch manager. So, in November 2021, he received a show cause letter accusing him of sleeping on 11 specific dates from October 2022 to April 2021. In his defense, he argued there's a three main point that he argued, which is he did not intentionally sleep, he only dozed off or terlelap, sometimes during lunch hour. He suffered from severe obstructive sleep apnea, a medical condition that causes involuntary sleep episodes. And the third one is some of the witnesses presented by the bank were biased and held personal grudge. So, on the other hand, the bank argued that his behavior clearly breached their code of conduct, and as a branch manager, he should uphold high disciplines because other staff were looking at him for the leadership. Okay, so here is the issue to be determined. The industrial court examined the case based on three main legal issues, which is did the claimant commit the alleged misconduct? Um, this required proof on a balance of probabilities as established in Milan Auto Berhad versus Wong So Nien. And the second one was the dismissal carried out with just cause or excuse. Following to the principle from Go New Boy versus JNP Codes, the court must assess whether the employer proved the reason relied upon. And the third one was the punishment of dismissal proportionate to the misconduct, which is the court applied the doctrine of proportionality supported by the federal court in Norizan Bakar versus Panzana Enterprise. Okay, so here we have a judgment summary, which is what the court's finding. So on the first issue, the court found the claimant did commit the misconduct, which is the bank tendered photograph showing him asleep in his office. And during examination, he admitted he had terlelap. Even though some incident happened near lunchtime, the court accepted that sleeping, even briefly, is still a form of misconduct, especially for someone in a managerial role. However, the court also acknowledged weaknesses in the bank's witness testimonies, such as inconsistent statement. Despite that, the photographic evidence was very strong enough to prove the misconduct accurate. Several mitigating factors influenced this decision, which is it was Clyman's first offense of his nature. The second one was the branch under his leadership consistently met sales target, demonstrating strong performance. And the third one, his medical report show he suffered from a serious sleep disorder. Last was the bank had alternative punishment available, such as warning letter or demotion, but did not utilize them. Because of this factor, the court decided that dismissal was too harsh and therefore without just cause or excuse. So here remedies awarded. Even though the claimant won his case, the court decided not to reinstate him. There were practical reasons for this, which is he was close to retirement, his position had already been filled, and the working relationship between the parties had deteriorated. Instead, the court awarded which is 21 months of back wages and 11 months of compensation in lieu of reinstatement, totaling which is RM 480,786 before deductions. However, the court made a 50% deduction for contributory misconduct because the claimant should have been more responsible as a senior manager, and the final amount awarded was 240,384 ringgit. So, analysis of the judgment. Let's analyze why the court reached this decision. A key principle applied was the doctrine of proportionality. This means that while sleeping at work is real misconduct, the punishment must fit the seriousness of the behavior. The court believed the offensive behavior did not reach a level that justified the industrial capital punishment, which is dismissal. Supporting authorities such as Dreamland Corporation versus Chong Chin Siu state that even if a domestic inquiry is imperfect, the industrial court must rehear the matter and reach a fair outcome. The court balance misconduct with mitigating factor and also conclude the dismissal was excessive in this situation. So here, critique strength of judgment. The first one here, which is it protect employees from overly harsh disciplinary action. It encourage employers to act reasonably and apply consistent discipline procedures. It reinforces that a single offense, especially one influenced by medical condition, should not automatically lead to dismissal. It aligned with principle under Section 30 IRA, which emphasize equity and good conscience. The ruling also sent a message that employers should consider an employee's overall service record, which in this case was excellent. Here was the critic witness employer's perspective. So, as a branch manager, the claimant have a high level of responsibility, which is sleeping in the office, even briefly, could damage staff morale and reduce confidence in his leadership. This industrial court acknowledged this by applying a 50% deduction for contributory misconduct. This shows the court did not excuse the misconduct entirely but aimed for a balanced outcome that reflected both sides' position. And finally, for the conclusion, what can I say? To conclude, this case demonstrates that proven misconduct does not always justify dismissal. Industrial discipline must be fair, proportionate, and considerate of the employee's context, especially where health issues are involved. The court ultimately ruled the dismissal to be without just cause or excuse and awarded appropriate compensation. This case set an important excellence for both employees and employer regarding fairness, responsibility, and proportionality in workplace discipline.